Now, what is the distinction between essential, natural, and accidental elements of a contract? When you say essential, these are elements without which there can be no contract. So the absence of an essential element will make the contract void. That is why, remember, in marriage, Article 4 of the Family Code, the absence of any of the essential or formal requisites will make the marriage void ab initio. The defect will make the marriage voidable. Natural elements, it is already presumed to be existing. It's already within the contract. For example, in a contract of sale, even if there is no stipulation by the parties, warranty. Warranty against eviction. Warranty against hidden defect. But that warranty does not apply in marriage. Diba? Pwede bang sabihin mo sa mother-in-law mo, naloko ho ako. Akala ko ho ang asawa ko ay ang ganda-ganda. Unang gabi, nagtanggal na ng makeup ang wife ko. Natakot ako. There is no warranty against hidden defect. Nung pala, puro artificial na nakalagay, no? Puro accessories. Hindi mo na pwedeng isole. Diba? Because warranty is not a natural element of marriage, but it is a natural element of sale. Accidental elements, it will only exist upon the stipulation of the parties. So, for example, sale of a real property, you allow that it can be paid by installment. And even if it is paid by installment, instead of a contract to sell, it becomes a contract of sale because of trust and confidence. And you know very well the distinction between contract to sell and contract of sale. Contract to sell, ownership will be dependent upon what? The fulfillment of the full obligation, which is payment of the contract price. While in contract of sale, there is transfer of ownership immediately. So kung pumayag kayo kahit na by installment, pero sige na, contract of sale na. That is simply an accidental element. Now we go to the essential elements of a contract. Because class, if ever there is any question in the bar exam, usually it is phrased like this: is the contract valid? Now, before you answer that question, whether the contract is valid or not, go back to the problem of the case and find out, now this time, according to perfection, the elements of the contract will vary. Is it a formal contract? Is it a real contract? Is it a consensual contract? So, when it comes to a solemn or formal contract, the elements for a valid solemn or formal contract are, number 1, consent. Number 2, subject matter. Number 3, cause or consideration. And number 4, formality required by law. The absence of any of these elements will make the solemn, formal contract void ab initio. Okay? We'll first look at the other elements of the other contracts because they have a common denominator. When it comes to a real contract, what are the elements of a real contract? Number 1, again, there is consent. Number 2, subject matter. Number 3, cause or consideration. And number 4, delivery of the thing. So if you will notice, the first 3 essential elements in a real contract are the same essential elements in a formal contract. It is the 4th element that is different. In a formal contract, the formality required. In a real contract, the delivery of the thing. So that means, if you are entering into a real contract, which as I've said, example is pledge, deposit, if it is not reduced into writing, don't worry about it. It will not affect the validity of your contract. Okay? Because what is important is, aside from the 3 first elements, actual delivery that will make the contract valid. Consensual. Consensual, masyadong matipid, 3 lang. Consent, subject matter, cost, or consideration. That's why the consensual contract is what they call as an ordinary contract. Because general rule is that contracts are perfected by the meeting of the minds of the parties. The exceptions are the real contract as well as the formal contract. Okay? Now, we discuss thoroughly the important elements for a valid contract. So, in the event that you will be asked, is the contract valid? Ang unang step, parang checklist. Lahat ba nitong elements na to present? If one of the essential elements is absent, then you can safely answer the question, the contract is void. So, we first talk about consent. Now, that's the definition given by Castan, accord or coincidence of the desires and intent of the parties to the contract upon the subject matter and the cause. How is consent manifested? There is a concurrence of the offer and acceptance. Yung usual ano lang natin, bibili ka ng isang bote ng tubig. Titingnan mo, uy, ano ba to? Mineral water o kaya distilled water? Di ba may mga ano yan? May mga label? O ilang ml ba yan? Kung 10 pesos, bakit ito 10 pesos pero 200 ml samantalang yung isa 10 pesos pero 700 ml tapos mineral water pero distilled. Di ba mas mahal ang distilled? Distilled water siya. So, syempre, kung wise consumer ka, ang kukunin mo yung 700 na ml at the cost of 10 pesos at the same time distilled. Di ba? So, pag nakita mo na yon, okay, pinakita sa iyo yung ano, ayan na. Tapos, sinabi mo, o sige, kukunin ko na yan. That in itself is what? Concurrence of the offer and acceptance. Now, what about contracts by correspondence? Ibig sabihin, ipapadala lang. Lalo na ngayon, baka mamaya ang ibigay na exam is through, hindi na LBC, high-tech na tayo, through text message o kaya through internet. Now, if under Article 1319, Paragraph 2, it says, consent exists as soon as offerer learns of acceptance by offeree. Now, just simply make use of that general principle, even if the problem in the bar talks about internet, sending acceptance through internet, or sending the acceptance of the offer through text message. So, the controlling factor there is when is the acceptance? When has it reached the knowledge of the offerer? Because it's only when the acceptance reaches the knowledge of the person offering it, that's where we can say that there is concurrence of the offer and acceptance. So kahit na ngayon, nag-email ako, samantalang 1 week pa niya, afterwards, binuksan yung email niya. So ang reckoning point doon, hindi yung pag-i-email ko ngayon, kung hindi yung pagbubukas ng email niya at kailan niya nabasa. Kung kailan nabasa ng offeror. Okay, ganun din. Pag nag-text ako, di ba minsan nagte-text ka samantalang hindi kagad natatanggap ng recipient mo. Pwedeng nasa isolated area or if not, low-bat siya, tapos ang tagal muna bago siya nakapag-charge ng battery niya, so na-delay yung receipt ng acceptance. So what is controlling is, as I've said, when did the offeror finally learn about the acceptance of his offer by the offeree? So that we can say that there is really consent. Okay? Requisites of an offer, the acceptance of which will perfect a contract. When can you say that the offer is valid? First, it has to be definite, it is complete, and there is an intention on the part of the offerer to be bound. Class, flyers are always distributed in the streets nowadays. And if you will look at the flyer or brochure, what do you see? You see the picture of what? If what is being offered there is condo unit, di ba? May picture ng condo unit. O kaya yung kung real property, makikita mo yung pangalan ng developer, sabi natin Metrogate or by Ayala Land, Avida, Okay, may Avida nakalagay, tapos nakita mo yung isang picture ng yung Avida, let us say, there's one property in Bataan, Morong, Bataan, that is being developed by the Ayala Island, not Island Cove, but it is similar to that of an island cove. So, in relation to what we're discussing right now, can we consider that piece of paper being distributed as a definite offer? Nandun yung picture, nakalagay, contact, Juan de la Cruz, ito yung number. Pagtingin mo sa likod, nandun yung map kung saan ka pupunta. Is that an offer? The acceptance of which will perfect a contract? O minsan ngayon, di ba, ang hindi lang ganun ang ini-distribute. Mayroon kayong matatanggap na isang maliit na papel. Nakalagay doon, you want to obtain a loan? 100,000 pesos. Tapos nakalagay sa kabilang side, 1%, 200,000, 2%. Is that an offer that is complete, that is definite? The acceptance of which will perfect a contract? Remember the requirement so that the offer will really perfect a contract is that it should be definite, it is complete, and parties really have the intention to be bound by the contract. Definitely, the distribution of the flyer, there is really the intention to be bound, isn't it? So it will now only bring us to the question, is it definite? Is it complete? Pag nakita mo na ba yung picture ng bahay na binebenta, will you be satisfied? If you are a good buyer of a real property, together with its improvement, first you have to take a look at what? The location. Second, if it is a house, you have to look at the materials used in the house. So by just simply looking at that piece of paper, that means that the offer cannot be complete and definite. Why? Because you still have so many questions in your mind. So for as long as you have so many questions in your mind regarding the offer, then we cannot say that the offer is complete and definite. So what is that piece of paper in relation to the civil code? It is simply an invitation for you to make an offer. What kind of offer? An invitation for you to make an offer to buy the property. So, tatawagan mo Avida, uy, may nakita ho ako sa dyaryo, eto, meron pala kayong binebenta sa Morong, Bataan. Can I see the property? So, that alone, the fact that you call Avida, that is a response to their invitation for you to make an offer. You get it, class? Sa ad, di ba may makikita ka? For sale. 2 bedrooms. 2 car garage. And then, 1 room for maid. Tapos, 1 swimming pool. Question, will that be considered as a definite and complete offer? Na pag nakita mo lang yung, uy, nakasulat dito, may 2 car garage. So, ibig sabihin, magkakasya 2 sasakyan ko. Uy, may swimming pool, okay na to. Will you take the risk of calling the owner and telling the owner, okay na, perfected na yung contract, bibiling ko. Hindi mo man lang titignan. Di ba? Hindi. Bakit? Kasi marami ka pang gustong malaman tungkol sa bahay. Gusto mong malaman, may lumalabas ho ba dyan sa gabi? Baka may makasabay ako naliligo sa swimming pool. So, for an offer to be definite, obviously, there's no more question in your mind. And the only thing that you have to do is to what? Accept the offer. Which, if you will now connect it to Jollibee, pag pumasok ka sa Jollibee, ano unang bubungad sa'yo? Bukod sa mukha ng mga kahera. Diba, pag tumingin ka sa ang unang nakalagay dyan kagad, may picture sila. Diba? Tapos, ano makikita mo sa picture? Kagaya ng for breakfast. O, eto yung nakalagay, may makikita ka ano ang size ng drink. At ano ang size ng French fries. Ano ang hamburger? Meron bang tomato, merong lechugas, etc. And with that, nakalagay na rin doon, this is the cost. Is that a definite or complete offer? The acceptance of which will lead to the perfection of the contract? Meron bang nagsabi sa inyo doon sa kahera, Ano ho bang tinapay ang ginamit nyo ngayon? Sa Goldilocks o sa Red Ribbon? Pwede ho bang makurot-kurot yung kung malambot o hindi? Di ba hindi? Pag nandun ka na, ano lang ang sasabihin mo sa kahera? Ma'am, I want value meal number 1. No further arguments, Your Honor. I just want value meal number 1. Di ba? So that means that what is reflected in the tarpaulin is an offer, the acceptance of which will lead to the perfection of the sale of hamburger value meal number 1. Sa palengke. Di ba? Sa palengke, pag nakakita ka ng isda at gusto mong bumili ng tilapia, bibili ka ba kagad ng tilapia? Uy, tilapia ito. Can we consider that as a definite offer? Nakakita ka ng tilapia, nakalagay doon, ito yung presyo. Filipino culture, what do we do? Hahawak-hawakan yan, tatapik-tapikin, and then, oops, iaangat yung kung titignan kung pula o hindi, para malaman kung ano siya, kung sariwa o hindi. Ibubuklat ang mata, titignan kung may sore eyes or wala. Why? Because as a consumer, you want to be satisfied whether the product it is still fresh or not. So you cannot just compare buying of a tilapia in the wet market from buying hamburger in McDonald's. And from the point of view of the civil code, although there is an offer in both cases, the offer of Jollibee or McDonald's is complete, definite, the acceptance of which will lead to a perfected contract. But the offer of the tilapia in a wet market is not complete and definite. Why? Because you are not sure whether it is really fresh and you want to know whether it is fresh. How can you know it? Unless you hold the tilapia. Kasi pag malambot na yan, hindi na fresh yan. Hindi na pamantayan yung kung mapula siya o hindi. Malay mo, kinulayan, di ba? So, titignan mo ngayon kung medyo matigas pa yung body ng tilapia. Pag medyo matigas pa yung body ng tilapia, fresh pa yan. Okay? What else? Ito naman, requisites of an acceptance that will give rise to the perfection of a contract. Yung kanina, requisites for an offer. So that the offer, once it is accepted, will give rise to a valid or perfected contract. Ito naman, from the point of view of the one accepting the offer, what are the requisites so that the acceptance can give rise to a perfected contract? Number 1, acceptance is unqualified, unconditional. And number 2, very, very important, acceptance is communicated to the offeror. Kaya diba minsan, sino nagpupunta sa Divisoria dito? Pag nagpunta ka sa Divisoria at nagtanong ka ng pagpipilitan sa iyo minsan ng mga nagtitinda sa palengke. Hindi mo naman po pwedeng sabihin, sige ho, pagdating ko sa bahay at halimbawa is lamog pala yung mangga, ibabalik ko. If there is a condition, that is an unqualified acceptance and it cannot give rise to a perfected contract. Kung makikita mo, class, kung ano yung ginagawa nyo everyday, without you knowing it, you are applying the provision of the code. Ito yung offer ng tindera, offer, pero hindi definite kasi hindi ka sigurado kung matamis yung pakwan. Sa mangga, may nagpapatikim ba ng mangga? Ang sabi ng nanay ko, para daw malaman kung ang mangga ay matamis, ano gagawin mo? Sige nga, aamuyin mo. Para malaman kung matamis ang mangga. So that means, if you see, there is one basket, hindi ibig sabihin, bibili ka kagad. Kailangan aamuyin mo pa kasi hindi definite ang offer. Okay? What about the nature and effect of advertisement? Kanina, na-mention ko na yan sa inyo, di ba? Tingnan nyo. Kaya ngayon, linggo ngayon, anong newspaper ang napakakapal pang linggo? Manila Bulletin. Santambak ng advertisement. But insofar as the civil code is concerned, what is the significance of this advertisement? Definitely, if it involves the sale of a real property or personal property, diba, they cannot be a definite offer, but they are simply an invitation to make an offer. Kung titingnan mo, kahit sa ad ngayon, especially sa mga equipment, Di ba may drawing na, may picture na? But in spite of that, will you now consider it as a definite offer? Hindi pa rin. Kasi kailangan i-test mo. Lalo na, di ba, yung mga pang-gym na makikita mo, meron ng picture pag naka-add ngayon sa sa newspaper. Yung mga treadmill, yung mga So, hindi pa rin as a buyer, you are not satisfied yet. So, there is simply what? An invitation to make an offer. Now, what is a counter-offer? Counter-offer is a qualified or conditional acceptance. So, ito yung nakikipagtawaran ka. Okay, option money, earnest money, what is the distinction? Similarity definitely both involves the delivery of money. But the distinction is with respect to the effect. If it is an earnest money, that gives rise to a perfected contract of sale. Earnest money forms part of the contract price. An option money does not give rise to a perfected contract of sale, but simply a perfected option contract. And what is that option contract? You are given a reasonable period by the vendor within which to make a final decision as to whether you will push through with the buying of the property or not. So the money or the consideration, which is called option money in an option contract, is a consideration for the waiting time of the seller. Now, how much should be the option money? The code is silent about it. So, 1 peso will be enough. Enough to tie down the seller that within a period of 1 week or 2 weeks or even 1 month, as agreed upon by both parties, seller has no right to offer the same product to a third person. But if there is no option money given, seller has the full discretion of disposing the property to a third person, even without the knowledge of the buyer. Now, class, I don't think that you have already encountered a contract wherein the terms option money or earnest money appear. Okay? Usually, what is being used by brokers, deposit or reservation fee. Now, look at the stipulation. Regardless of whether it is termed as deposit or reservation fee, for as long as that deposit or reservation fee will be included in the computation of the contract price, then that means that is an earnest money. But if it is not included in the computation, it will not be deducted from the contract price. It will be deemed forfeited in case you will not push through with the buying of the property. That is simply an option money. So option money, what is perfected is the option contract wherein you are buying the period to what? Make a final decision as to whether you will acquire the property or not. Earnest money gives rise to a perfected contract and it forms part of the contract price. So we now go to the vices of consent. Now, vices, these are circumstances that affect adversely the decision of a party in entering into a contract. Now, your knowledge of the vices of consent in the contract of marriage will definitely help you a lot. And as I've mentioned earlier, Article 4 of the Family Code is very clear. The absence of any of the essential requisites will make the marriage null and void. The defect will make the marriage voidable. So when you talk about defect, class, that means the element is present, okay? But there is something wrong with the element. And the reason why there is something wrong with the element, for example, in this case of consent, there is consent, but it was not freely given. And the reason why it was not freely given, because of the presence of any of these vices of consent. Now, take note, the vices of consent can be classified into two. You have the vices affecting cognition and the vices affecting volition. Remember that as a rational being, we have two faculties, the intellectual faculty, so that refers to the cognition, and the faculty of the will, that refers to the volition. So, what are the possible vices that might affect the intellectual faculty of a person? So, you have incapacity, error, and fraud. Although, if you will notice, similar to that in the case of marriage, what really affects cognition is error and fraud. Incapacity is in relation to your Article 3738 of the Civil Code, the restrictions or the limitations as to one's capacity to act. Now, what will affect the volition, the faculty of the will, would be violence, intimidation, undue influence. Okay? We'll now discuss them thoroughly. Error or mistake, the inadvertent and excusable disregard of a circumstance material to the contract. Error or mistake. We now apply it again to, I always go back to the family code. Mistake of fact, not mistake of law. Definition of good faith between the contracting parties. Mistake of fact. Good faith refers to mistake of fact, not mistake of law. That's why, if the parties believe in good faith that the person solemnizing the marriage really has the authority, but it is a mistake of fact, so that good faith of the contracting parties will save the validity of the marriage. But if the one who solemnized does not really have the authority, even if the parties believe in good faith, the good faith of the contracting parties will not make the marriage valid. Because the last one involves a mistake of law, not a mistake of fact. Example, the former Secretary of Justice, Raul Gonzalez, since he has the title of a justice, he celebrated your marriage, and since according to the family code, members of the judiciary, and thinking that a person who holds a title of a justice is automatically a member of the judiciary, you believe in good faith that Justice Raul Gonzalez had the authority. Will the marriage be valid? No, because that is tantamount to a mistake of law, not a mistake of fact. Justice Raul Gonzalez is a Secretary of Justice. The incumbent court administrator is Maidas Marquez. So if his name appears in the bar exam, Justice, so he has the title of a justice. Justice Maidas Marquez celebrated the marriage. That is tantamount to a mistake of law, not a mistake of fact. A court administrator is not given the authority. But when can it be considered as a mistake of fact? If Juan de la Cruz, an ex-seminarian expelled from the seminary, decided to continue his mission by being a sacristan, and then one day when the parish priest was incapacitated to celebrate the marriage, he misrepresented himself to be the parish priest. He celebrated the marriage, and the parties believe in good faith that the marriage was solemnized by the assistant parish priest. Is the marriage valid? Yes, the good faith of the contracting parties saved the validity of the marriage, because even if he is not in reality a parish priest or a priest, but since the parties believe in good faith that he was a priest, and a priest is given the authority to solemnize marriage, then the good faith will make the marriage valid. So similarly, but that is a special law, the family code is a special law. But in general, if there is an absence of a special law, we have no choice but to apply the general provisions under the Civil Code. So if it is an error or a mistake, no qualification, whether it is a mistake of fact or a mistake of law. What the Civil Code is telling us, if it will affect a material decision on the part of the party in entering into the contract because of that mistake, because of that error, then that is considered as a vice of consent, and therefore will be a ground for the annulment of the contract. The consent is there, But if you're aware of the mistake, if you're aware of the error, you would not have given your consent. And that is why the contract is considered as voidable. So we'll be discussing annulment of contracts, the voidable contracts, rescissible contracts, and enforceable contract. But insofar as voidable contracts are concerned, you have to connect it with the vices of consent. Because as I've said, similar to that in the contract of marriage, if the consent is not really given, there is consent but not really given, it is a ground for the annulment of the contract. The contract is voidable. Okay? Fraud, insidious words or machinations whereby the other is induced to execute a contract. As a matter of fact, class, you go as far as your insurance law. We do not just limit ourselves to the family code. In insurance, you know very well that if there is fraud, which involves concealment, isn't it? That will be a ground which can be invoked by the insurance company so that the benefit that can be enjoyed by the person insured will not now be enjoyed by him. Why? Because of fraud concealment. In the family code, fraud is only limited to 4 cases. Expressio unius rule. If it will not fall under the enumeration, any other kind of fraud will not be a ground for the annulment of marriage. But I'm referring to 2 special laws, the insurance code as well as the family code. So in the event that you will be confronted with a problem in the bar exam, wherein the case has nothing to do with insurance, has nothing to do with marriage, so there is no special law, you just simply apply the general provision in obligations and contracts. That the presence of fraud will be a ground for the annulment of the contract. Ano ba yung sa Tagalog ng fraud? Paglilinlang, pandaraya, di ba? So kung alam mo yung totoo, hindi ka oo, di ba? So fraud. And there are different kinds of fraud. You have to group them into 2. You have the fraud in the celebration of the contract and the fraud in the execution of the contract. So what would affect the validity, therefore, is the fraud that is present in the celebration of the contract. Remember the distinction between annulment and nullity in marriage. In nullity, the ground is already existing even prior to the celebration of the marriage. In annulment, the ground is existing at the time of the celebration. So, this is what we call as, in relation to fraud, the dolo causante. The fraud that is present in the celebration of the contract. So, the party would not have given his consent if he is aware that there is fraud. There's a reason why it is a ground for the annulment of the contract. Dolo causante. The other one is dolo incidente. Party deceived would have agreed but under different terms. So if you will notice the distinction between dolo causante and dolo incidente, in dolo causante, if you're aware of the fraud, you would not have given your consent. In dolo incidente, even if you're aware of the fraud, you would still give your consent but under a different term or condition. That's why it is the dolo causante that is a ground for annulment, not the dolo incidente. Because in the dolo incidente, there is still the intention to enter into a contract. So the only remedy is to ask for damages. Okay? The other one is fraud in the execution of the obligation. So since the contract is already perfected and the fraud only appears in the execution of the obligation. And remember that the obligation arises from a perfected contract. Therefore, that is a fraud that cannot be used as a ground for annulment, but simply for damages. So here you have to determine in the problem what kind of fraud it is. Is it a fraud that is existing at the time of the celebration of the contract? Or is it a fraud that is existing after the celebration, but during the execution of the obligation? Because if it is during the celebration, it's a ground for annulment. But if it is after, then it is only a ground for damages. Which by analogy, again, we connect it with marriage, isn't it? If the ground is existing at the time of the celebration, your remedy should be annulment of marriage. But if the ground is existing after a marriage that was celebrated, it is a ground for legal separation. Kaya nga, di ba, pag may concealment ng lesbianism, homosexuality, drug addiction, annulment of marriage. Pero, pag wala namang concealment, pwede ka pa rin magdemanda, but this time, your remedy will be legal separation. So, yung mga hairline na ganong kailangan wag niyong kakalimutan. Okay? Violence. In order to wrest consent, serious or irresistible force is employed. Now, take note, the violence as contemplated under the code does not only refer to physical violence, because you can be tortured mentally. But then, if you will connect it with your criminal law, as well as with your property, remember in property, the doctrine of incomplete self-defense, diba? Ano yun? Defense of one's property. But what is necessary is, at the time that you are using, what? Reasonable force, there is an actual threat to usurp you or remove you from the possession of your property. Which, if you will connect it to your criminal law under the revised penal code, that is self-defense. Defense of one's person, one's property, and defense of the life of your relative. So, kung titignan mo, konektado sila, di ba? So, eto naman, because of violence, natakot ka dahil papatayin ka, kukunin yung property mo, papatayin ang kamag-anak mo, you had no choice but to give your consent. So, nandun yung consent, present, pero defective. Not voluntarily given. Intimidation, pananakot, threat. The kind of intimidation that would really vitiate one's consent is in criminal law, what we call as grave threat. Diba? That's why if you will recall, there's one case in marriage, the case of Ruiz, lawyer, who claimed that he was threatened. Tinakot siya para pakasalan yung babae. That's why I always repeat to my students, without offending you guys, I do not believe in a shotgun wedding. Yung pinikot. Pikot kasi ako. Kalokohan niya, pinikot. Pinikot, 10 ang anak mo. Pinikot ka pa rin. Sa lahat naman ng tinakot, wag mo sabihin, during the sexual act, tinatakot ka. Saan ka nakakita ng lalaking tinakot ng asawa niya, kahit na sabihin mong Batanggenya, di ba? Tinutukan mo ng balisong ang lalaki. Paano tatayo yan? Paano magkakaroon ng copulation? Although sabi ng isang estudyante ko doon sa review ko sa Cotabato, ma'am, tatayo pa rin. Hindi ko pa nagagawa sa asawa ko yon. Titignan ko. Diba? So, paano magkakaroon ng pikot? Okay? Unless literally talagang yung ipapakasalan mo, angkan talaga ng notorious family, tapos talaga alam mo, may mga weapons sila na nakatago doon sa bahay. So, intimidation. So, that kind of intimidation is not only applicable in marriage, but in any kind of contract. Okay? Undue influence. Dito pumapasok yung moral ascendancy na tinatawag natin. Improper advantage of one's power. Although, come to think of it, class, you might have heard of a case involving a teacher falling in love with a student. Diba? And what did the Supreme Court say? The court has no right to interfere if the teacher fell in love with the student. So, hindi naging proper yung defense ng undue influence. Now, what could be another possible application of this undue influence? Of course, the dean influencing you. Okay, there could be a possible undue influence, or here is a government official, so you have no choice but to say yes to him because you're afraid. Or in relation to your employer, you're afraid that if you will not agree to what he's telling you might be terminated from employment. So these are examples of what is the meaning of undue influence. Okay? Simulation of a contract. I think all of us are aware of what this simulation is, and all of us have already entered into a simulated contract. Especially when it comes to what? Trying to get rid of the BIR. Although, in so far as the civil code is concerned, okay, when you say simulation of a contract, declaration of non-existent will made deliberately and by agreement of the parties. Now, simulation of contract can be an absolutely simulated contract or a relatively simulated contract. When you say absolutely simulated contract, there is no real intention to enter into a contract. And this is what most Filipinos did when the agrarian reform was enacted. Isn't it? Most of the hacienderos and haciendera, so that their property will not be covered by CARP, what did they do? They made it appear, chop, okay? Sell it, or if not, donate it to a third person to reduce the area, while in truth and in fact, there is no intention to dispose the property. That is an absolutely simulated contract. You have an instrument, there is signing of the document, even if it is entitled deed of sale or deed of donation, but if the real intention of the parties is not really to dispose it, only to remove it from the coverage of CARP, then, insofar as the contract is concerned, it is inexistent. It is void ab initio. On the other hand, there is such a thing as a relative simulation. In a relative simulation, parties really intend to be bound to each other, but the real intention is not reflected on the instrument. Best example, as I've mentioned, so that you cannot be covered by the capital gains tax, usually what the parties would do, instead of making a deed of absolute sale, what they execute is a deed of donation. In worse scenario, sometimes they even ask for a BIR ruling for the exemption of a donor's tax. But there is really intention to dispose the property. But that real intention is not appearing in the document. So what we have now is a relatively simulated contract. And usually, this is what brokers of real estate do. Diba? Yung isang kontrata, that is the hidden contract, which we call hidden contract. The real value is reflected. Yung isang kontrata, that is the relatively simulated. The real value is not written. And what value appears in that relatively simulated contract? Usually, the one that is the zonal value given by the BIR. Because if you really want to lessen the capital gains tax, although I am not encouraging you to do it, class, you take a look at the zonal value. You can even use the site of the BIR, and you will be surprised. The zonal value is usually twice lower than the fair market value. Minsan, hindi lang twice lower than, thrice. Because BIR does not immediately change the zonal value. So there is a difference between the zonal value and the fair market value of a property. So if you want to pay less capital gains tax, you peg the contract price at the zonal value. But in reality, what you paid is the fair market value. And if you will be doing that, you are making a relatively simulated contract. So it's still valid between the contracting parties. Okay? We now go to subject matter or object. Insofar as obligations and contracts is concerned, object is what? It's an ambiguous term. Ambiguous in the sense that the object per se refers to the property if it refers to a prestation to give. Okay? Which I mentioned this morning, property, which is different from a thing. Why? Code, USA, utility, substantivity, capable of being appropriated. So you ladies, if the boy courting you will tell you, I will give you the moon, the stars, sampalin mo. Bakit? Because the moon and the stars, they are things, but they are not property. They're useful, substantive, but not capable of being appropriated. Diba? So it's only a thing. It is not a property. And for it to be a valid object of a contract, it has to be a property. It has to be within the commerce of men. So if you will be buying a wild animal, DENR can run after you. Or if you will be buying an animal that has already been declared as outside of the commerce of men. For example, ano yung mga animals na hindi mo pwedeng ibili o ibenta? Diba? Yung mga pawikan. Kasi ito yun na yung about to be extinct. There are birds that cannot be, what? Sold in public. So if you enter into a contract of sale, then the sale can be assailed. Why? Because the object is outside of the commerce of men. Kanina sinabi natin, yung mga peanut butter na pinawithdraw sa market, it's already deemed as outside of the commerce of men. Okay? So, object. At the same time, remember, another meaning of object under obligation is it refers to the prestation. Prestation to give, prestation to do, prestation not to do. And we mentioned this morning that the prestation should be lawful. It should be possible. Because if it is impossible, it cannot be done, then debtor is relieved from his obligation. Now, cause or consideration, that is the what? Reason why you entered into a contract. If I will ask you, class, there are so many review centers. What compelled you to enroll in San Sebastian? Compelling reason that push you to enter into that contract. Bakit ka bumili ng McDonald's at hindi ka bumili ng Jollibee? Diba? Cause or consideration, which is different from motive. So if you want to enter into a contract of sale with Jollibee or with McDonald's, the cause or consideration there is because you want to get hold of the burger. I want the burger. But the motive can be different. I want the burger because I want to give it to my classmate. I want the burger because I want to eat it. I want the burger because I'll bring it to my kid as pasalubong. So you see the distinction between motive and cause or consideration. The motive is something that is incidental. It has nothing to do with the perfection of the contract. So from the point of view of the tindera of Jollibee or McDonald's, wala siyang pakialam kahit anong gagawin mo sa hamburger. Ang importante sa kanya, what compelled him to enter into a contract of sale with you? Kailangan ko yung pera mo. Ibigay mo yung bayad. At ako naman, ang obligasyon ko, ibigay ko sa iyo yung hamburger. Kasi alam ko, kaya ka nag-enter into a contract of sale ng hamburger, gusto mo yung hamburger. Now, it is immaterial for me as the representative of Jollibee kung saan mo dadalhin yung hamburger. What will be your motive? Pwedeng kaya ka bumili ng burger, gusto mong malaman, siguro para kang scientist, gusto mong ma-dissect, ano bang laman itong hamburger na to? Diba? Hindi yung pala kakainin. That is motive. So you see, class, the distinction between cause, consideration from motive. It is the cause or consideration that is an essential element of a contract. Motive is not. Motive will not affect the validity of the contract. So bakit ka nagpunta sa pawn shop? Ang reason, gusto mong mangutang. Kaya ka nagpunta sa pawn shop. Gusto mong mangutang, kaya you're compelled to what? You're compelled to use your jewelry or your cell phone or laptop as a collateral. Because what push you is, kailangan kong mangutang. But it is immaterial from the point of view of the pawn shop owner, kaya ka pala nangutang ay para ano? Pambili ng gatas, pambayad ng tuition fee. That is motive. Is it clear? Now, class, the inadequacy of the cause will not invalidate the contract. As a matter of fact, when we talk about rescissible contracts, it is simply a ground for the rescission of the contract. Inadequacy. Because if you avail of rescission, the contract is valid. Okay? Now, the formality, it may be an essential element if the contract is a formal contract. Because the formality of a contract is necessary for validity if it is a formal contract or a solemn contract based on perfection, or the formality is necessary for enforceability if the contract falls under the coverage of the statute of fraud. That's why, class, I would like to encourage you, memorize what are those contracts that fall under the statute of fraud. Because what you can do, if you will be confronted with a question regarding formal requirements, checklist, baka nasa statute of fraud. Kung nasa statute of fraud, then failure to comply with the written requirement of the statute of fraud will not affect validity but simply enforceability. Diba? Tapos pag wala naman sa coverage ng statute of fraud, o tignan mo naman yung isang listahan, is it required under the law that non-compliance will affect its validity? Oy, then that will make the contract a formal or a solemn contract. And there are also cases wherein reducing it into an instrument is necessary only for convenience. Especially in the case of, take note, we mentioned when we were talking about payment, diba? Who has the burden of proving that there was payment? It has to be the debtor. That's why reducing it into writing is necessary for convenience. Now, in relation to this formality class, these are examples of solemn contracts. Solemn in the sense that if you do not comply with the formal requirements, the contract will be considered void ab initio. So, number 1 in the list, donation of a real property. Next one is a donation of a personal property, the value of which exceeds 5,000 pesos. Class, this donation of a personal property, you only have to remember it for purposes of passing the bar exam, not for purposes of applying it. Bakit? Kung nangliligaw ka, siguro maganda, wag mo nang i-apply, lalo na kung ang nililigawan mo, hindi ka sigurado na sasagutin ka. Kasi pag halimbawa, syempre, kung gusto mong magpakitang astig ka, di ba, anong ireregalo mo? Hindi ka magre-regalo ng perfume na libre. Di ba? May mga perfume na libre na napakaliit. So, syempre, ang bibili mo yung napakalaking bottle ng perfume. Eh, kung talagang perfume yan, hindi yan Johnson & Johnson o kaya cologne lang, magkano ang presyo nun? More than 5,000. Now, if you will be applying strictly the requirement under the Civil Code, if it exceeds 5,000, it has to be in writing. Sasabihin mo ba sa nililigawan mo, pwede ba pakipirmahan acknowledgement receipt? Eh baka iba to sa iyo yung bote ng perfume, di ba? Pero on the other hand, you are on the safe side. Bakit? Kasi pag hindi ka sinagot, pwede mong bawiin yung perfume. Because you can say to the girl that you're courting, oy, the donation is void since it was not reduced into writing. So, kung titingnan mo, may kalokohan pag in-apply mo strictly yung donation ng personal property. Because remember, class, donation, in layman's term is what? Regalo, gift. It's not the donation that is connected to foundation, charitable institution, or the church. Donation is an act of liberality. So, in layman's term, the donation is a gift. What else? Payment of interest. Interest cannot be imposed upon the debtor, especially if it is simple loan or mutuum, unless it is expressly stipulated. And to be expressly stipulated, it has to be reduced into writing. Otherwise, you cannot impose interest. That's Article 1956. Sale of a real property through an agent. It has to be in writing. Article 1874. Anticresis. What is anticresis? The anticretic creditor, anticretic debtor. Anticresis, that is also an accessory contract. And the right to possess is given to the anticretic creditor. The right to enjoy the fruits is likewise given to the anticretic creditor. Why? Because the fruits will now be applied as payment for the interest that is agreed upon, and afterwards, payment for the principal loan. Anti-crisis. But for it to be valid, Article 2134 requires that it should be in writing. Otherwise, it is void. What else? Partnership where the partner contributes a real property. It has to be in writing, otherwise it is void. So these are only some of the examples of a solemn contract. And let me repeat, the formality here is an essential element for validity. Non-compliance will make the contract void. But it does not necessarily follow that all contracts are solemn contracts. But even if they are not solemn contracts, there are cases wherein there are other formalities required by law. So, I want you to memorize what are those contracts which should be reduced into a public instrument, not because it is necessary for validity, but for them to be enforceable. Okay? If you will notice, class, so I'm referring to Article 1358, I highlighted certain letters again to help you remember if in case you will be asked to enumerate. So number 1, contracts for the creation, transmission, modification, or extinguishment of, take note, we are referring to real rights. And in relation to property, when you say real right, it is a right that is attached to the real property. So what is an example of a real right? Right to usufruct, right to lease. Okay? So if there is a right to lease that is created, then it has to be in a public instrument to be enforceable. Okay? Although if you will notice here, I mentioned exception. Why? Because although that is the requirement under 1358, if you will remember, in your statutory construction, if there is a general provision and a special provision, the special provision should prevail. Or between an earlier provision and a latter provision, the latter provision should prevail. So in this case, the earlier provision is 1358, but then we have the Statute of Frauds. And under the Statute of Fraud 1407, if the lease contract is for 1 year, it has to be covered by the Statute of Fraud. And what is the requirement under the Statute of Fraud? It should only be in writing. It need not be in a public instrument. That is why I mentioned it as one of the exceptions. Okay? The other exception is the sale of real property. But other real rights, if it involves creation, take note, I mentioned there, C met. That is my code. C for creation of real right, M for modification of real right, E for extinguishment of real right, and T for transmission of real right. A public instrument is necessary. So I hope that the code will help you remember. C met. C for creation of real right, M modification, E extinguishment, T transmission. But we're only talking of real right, not real property. Okay? So remember the distinction between a real right and a real property. A real property is an immovable property. It's a classification of property based on mobility. And that is the reason why a contract of sale of a real property does not fall under number 1 because it is not a real right. A real right is a right that is attached to the property. So regardless of whether that property is transferred to another person, the real right is still existing. And as I've mentioned, right to usufruct, the easement existing on the property, that is also a real right. Is that clear? Okay, the next in line is, our code is war. And we are talking of what? Hereditary rights. W for waiver of hereditary right, A for assignment of hereditary right, and R for repudiation of hereditary right. But take note, class, when it comes to waiver of hereditary right, you have to connect it with Article 6 of the Civil Code, waiver of right. Why? Because for a waiver of a hereditary right to be valid, number one, the right should be actually existing. Number two, the holder of the right is knowledgeable about his right. And number three, the one waiving the right is voluntarily waiving the right. So the reason why I am emphasizing this, it is because if the waiver of hereditary right is made prior to the death of the deceased, even if there is compliance with the public instrument requirement, it cannot be considered valid. Why? Because of Article 6 of the Civil Code. The right is not yet actually existing. So if you will notice, we're connecting obligations and contracts with the preliminary title under the Civil Code. Okay? And then the other one, if there is waiver, assignment, repudiation of the conjugal partnership of gains. So yun, war. Third, the third one has something to do with the power to administer. So of course, if it refers to power to administer the property, then that has reference to what? The SPA or GPA, Special Power of Authority or General Power of Authority, to administer the property of another person. Okay? And the other one, cession or assignment of action or rights arising from an act contained in a public instrument. Okay? What can be an example of this? If you will remember, isn't it, we mentioned before, the so-called action subrogatoria, creditor exercising the right of the debtor to file an action against the debtor's debtor. So it should appear in a public instrument. Okay? So 1 to 4, these are contracts that should be in a public instrument so that they can be enforceable. Not because the requirement of being in a public instrument is necessary for validity. Remember what we have discussed before, the solemn contracts, okay? The formality there is necessary for validity. Is that clear? Now, we now go to the third group of contracts wherein the formal requirement is covered by the statute of fraud. And this is what I would like you to memorize also. Article 1403. Okay? And what is the requirement under the statute of fraud? That it should be in writing. And that requirement does not mean that the writing should be in public instrument. As a matter of fact, to be exaggerated, if you wrote it in 1/4 sheet of paper, okay, that is already compliance with the requirement of the statute of fraud. And what are the contracts enumerated under 1403? As I mentioned a while ago, if it is a lease contract for more than 1 year, promise to pay for the obligation of another person. And that is what? What kind of contract is that? If you promise to pay for the obligation of another person, you're acting as a guarantor. So, contract of guarantee or contract of surety. Although, another questionable item under the statute of fraud is what? Marriage settlement. Why? Because it will now be a question of how you will construe the formal requirement of a marriage settlement or antenuptial agreement under the family code and compare it now with Article 1403. Because, class, if you will compare the family code with the 1950 Civil Code, the 1950 Civil Code expressly states that a marriage settlement or antenuptial agreement shall be covered by the statute of fraud. And as we've said, if it is covered by the statute of fraud, the requirement that it should be in writing is only necessary for enforceability, not for validity. If in the bar exam, this question will be asked, here is Juan, married to Maria, okay, and before they got married, they entered into an antenuptial agreement wherein both agreed that the property relationship will be one of absolute separation of property. But it was simply a verbal marriage settlement. Question, is the marriage settlement valid? Okay? So how will you answer that? I'm giving you two options. Option 1, applying the opinion of Professor Tolentino in relation with the old provision governing marriage under the Civil Code and that of the Statute of Fraud, wherein Professor Tolentino says that even if the Family Code does not anymore have a provision that expressly provides that the antenuptial agreement or marriage settlement shall be governed by the statute of fraud, it is still covered by the statute of fraud. But do not forget to mention the name of the late Professor Tolentino, because in your legal research, the opinion of a commentator is considered as a secondary authority. The other option is invoking the opinion of Professor Santamaria, another commentator. In the opinion of Professor Santamaria, since the Family Code provides that the antenuptial agreement shall be in writing to affect third persons, okay, since it uses the word shall in your statutory construction, if the word shall is used, it is mandatory. Thus, in his opinion, if there is non-compliance of reducing the antenuptial agreement in writing, it shall be considered void. Up to now, there is no Supreme Court decision resolving the ambiguity. Okay? So you are given two options. Just make sure you cite or you may mention the name of Professor Santamaria if your position is that it is void, if it is not reduced into writing. Or you cite the name of Professor Tolentino if your position is that it is simply unenforceable for failure to comply with the requirement of the statute of fraud. Is that clear? Okay? And then the last group of contracts, it says, if the amount involved in the contract exceeds 500, it must be in writing. Again, if it is not reduced in writing, it will not affect the validity. So only those solemn contracts are the contracts that should really comply with the formality for it to be valid. Non-compliance with the formality will make the contract null and void. Okay? Unfortunately, class, we have no choice. You really have to memorize. But I hope the code will help you, as well as the words that I have highlighted. Is that clear? Now, if it is a real contract, aside from consent, subject matter or object, cause or consideration, the other essential element will be delivery. But if it is only a consensual contract, there are only three essential elements: consent freely given, subject matter or object, cause or consideration.